Respondents seek to exclude or to have struck out emanate from tweets that were published on Twitter. We don't seek to establish the truth of the contents of the tweets. What we seek to establish, and what I submit has been established, is that in respect of each and every tweet, that tweet was published on Twitter on the date and at the time that is reflected in the tweet, and emanating from a Twitter account whose name appears at the top of that tweet. I don't think there is anybody in this courtroom, and I don't know everyone in the courtroom, but I can confidently make the statement already. There is nobody in this courtroom who is. I beg your pardon, I just need to take a sip of water. Who doesn't know what Twitter is? Who doesn't know what a tweet looks like, and who doesn't know that tweets get published on this social media platform called Twitter by whomever has an account on Twitter, and you can say whatever you want. A maximum of 280 users can like them, they can retweet them, they can reply to them, and have a tweet of their own which attaches the tweet that is being. There are so many cases that have come to this court recently dealing with tweets, and it's now generally accepted by our courts, and certainly generally accepted by society, that when one sees a tweet, one knows that tweet and it says what it says for good or for bad, and it may contain absolute nonsense. But the fact is that that tweet was published and it says what it says. That's the only fact that that we seek to establish. We deal with a number of issues because we say that the legal offences raised by the respondents, as were contained in the affidavit, are misconceived. I've had a brief glance at the respondents' heads because they came through at about 6 o'clock last night. It seems as though there might be other arguments being advanced, but I have to wait for the reply in order to deal effectively with that. So for the moment, my argument is based on the papers, and in particular the respondents' answering affidavit. Milady, we deal first with the true nature of the complaint and the locus standi of the 6 complainants.
Because that's one of the points in limine by the respondent.
Yes.
Yes.
Yes. Because they say there's only one complainant before the court, and that is the first complainant, or Sanef. They say that the 5 individual complainants are not before the court. So I'll deal with that first. And then
and sorry, Mr. Berger, they are also questioning the authority
of Sanef.
Yes. Of Sanef. Yes. So I'm sure you're going to deal with that as well.
It is dealt with in the replying affidavit.
In the replying affidavit. Okay.
And I can take your ladyship. Then we deal with the jurisdiction of the Equality Court to consider and determine the complaint. It's only once your ladyship has jurisdiction that we can then consider the application to strike out. There's also
is the jurisdiction touched by?
Yes, the respondents dispute jurisdiction. The respondents, I'll elaborate on this. The respondents submit that we've come to the wrong court.
Yeah.
So we deal with the application to strike out. I will also say something about the application to refer to oral evidence. And then finally we will deal with the requirements for a final interdict, which is what we are seeking from this court. So as I said, my lady, the respondents, and a lot of the respondents' answering affidavit is based on this. Base their defense on the fact that they say there is one complainant before the court, Sanef, not 6. And they say that the evidence of the 5 individual complainants is relevant only to the extent that it supports the first complainant's evidence. But my lady, that contention is simply wrong. We've tried to ascertain precisely why how this argument arises. There's some suggestion that because the first affidavit because the founding affidavit of the first complainant is styled a founding affidavit, and the other affidavits are supporting affidavits.
Yes.
That therefore that means that there's only one complainant before the court. But that simply can't be right. Complaints are instituted in the Equality Court by virtue of a prescribed form, which is the Form 2, which is attached to the founding affidavit. Well, it's in the bundle of papers, and the founding affidavit is really attached to it. It's at page 1 of the record. The complainants have filled in there, see Annexure A for the particulars of the complainants. And if your ladyship goes to Annexure A, which is at page 6, your ladyship will see there are 6 complainants whose names and details and capacities in which they act are all set out. In relation to the second to the 6th complainants, your ladyship will see that they're all acting in their personal capacity. And in relation to the first complainant acts in terms of section 21C of the Act, which is any person acting as a member of or in the interests of a group or class of persons. The deponent to the founding affidavit, Ms. Matlasi, who is the chairperson of Sanef, says at page 11, paragraph 3.2, that Sanef is a non-profit organization which is capable of suing and being sued in its own name, which is common cause on the papers. And she then says that the organization advocates for the protection and promotion of ethical journalism and media freedom. Sanef institutes these proceedings in its own name, which actually is a section 21A capacity, and in the interest of protecting journalists and media freedom in South Africa. Now, when one reads the founding affidavit and the supporting affidavits, it's quite clear from all of those affidavits that And it's expressly said that each of the complainants seeks identical relief from this court. And the relief is set out in Annexure B, which your ladyship will find at page 8 of the papers. And each one of the complainants tells a story. But all the individual complainants, besides saying that they seek the relief, they say they also associate themselves with the complaint as articulated by the first complainant. So what's happened is that the first complainant has deposed to a founding affidavit, and the 5 individual complainants have joined with the first complainant to say, this is our complaint, we make common cause with this complaint, and we all seek the same relief. Now the first complainant in the founding affidavit sets out a sequence of events and also at times refers to the individual complainants. The individual complainants confirm what the founding affidavit says about them and then set out in detail how they have been affected by the acts and omissions of the respondents. And they all have a slightly different story to tell. But as I will explain in a moment, milady, their stories all revolve around a common matrix of facts. And that is that the respondents have made statements and issued tweets which have targeted the specific complainants and journalists more widely because of their reporting about the EFF and Mr. Malema. And they've targeted them in a particularly vicious way, and at times in a way that constitutes hate speech, at other times harassment. As a result of that conduct, followers of the respondent and Mr. Malema have themselves tweeted in response or at individual journalists or journalists generally. And this has created an environment which has become particularly toxic and hostile towards journalists. Instead of calling their supporters to order and saying, let's deal with this in an appropriate way, the respondents have often done nothing and at times have actually endorsed what their supporters have said about the individual complainants and journalists generally. So this complaint, yes, it's to a large extent about what Mr. Malema said outside the Zondo Commission on the 20th of November of last year, but it's more than that. And it goes to, and we detail in our heads, a number of particularly vicious statements that the respondents have made against the complainants and journalists generally. But I'll come to that. We say in paragraph 9 of our heads that this environment that has been created by the respondents is one that is calculated to stop the complainants and other journalists from reporting negatively on Mr. Malema and the EFF. And so as a result, the respondents deliberately refrain from condemning their supporters and instead condone their attacks on the complainants and other journalists. The relief that we seek in this referral is directed at interdicting the respondents from this course of conduct. In paragraph 12, I refer to the speech by Mr. Malema on the 20th of November 2018. And we say that this hate speech, republished by the EFF in its tweets following the speech, and I'll take your ladyship to that in a moment, led to a barrage of online abuse and harassment from supporters of the EFF, directed at the complainants and other journalists. It is clear from the chronology that the speech of 20 November 2018, significant as it is not the only act complained of. My lady, can I just deal with the issue that your ladyship raised with me about the authority of Sanef? In her affidavit, Ms. Matlasi says, at page 11, paragraph 3.3, that I've been authorized to institute these proceedings and to depose to this affidavit on behalf of Sanef by a resolution of its management committee, which is Annexure MM1, and that your ladyship will find at page 27. I'm not going to read the whole resolution, but there is a resolution there from the management committee, ManCom, which authorizes these proceedings. Now, the EFF and Mr. Malema say that ManCom doesn't have the power to authorize these proceedings. In reply, if I can take you to the replying affidavit, which your ladyship will find starting at page 472. Ms. Matlasi deals with authority at page 479. And she refers to the constitution of Sanef, which is Annexure MM1 at page 485, and in particular to clause 7.15 of Sanef's constitution. And 7.15 at page 490 reads as follows: the management committee will be responsible for the implementation of policy and for the administration of the forum, as referred by the Editors' Council. Ms. Matlasi says, and she, you'll recall, is the chairperson of Sanef. She says at 32 that ManCom is responsible for the day-to-day implementation of Sanef policy and administration. One of the express provisions of the Constitution contained in 429 is that Sanef is committed, amongst other things, to defending media freedom through all available institutions, including the Constitutional Court. The defense of media freedom, including the protection of journalists, is a fundamental Sanef policy. She then goes back to the founding affidavit and the resolution of ManCom dated the 5th of December 2018. She says, in the preamble to the ManCom resolution, it records a decision by the Sanef Council on 24 November 2018 to gather legal advice on possible recourse against the EFF, its leader and supporters. Complaints were then lodged on the 13th of December, and on the 9th of February 2019, the Sanef Council met again. She was present at that meeting of the Council. They discussed this matter. The Council noted that the matter was proceeding in this court, and the minute of the meeting, which she says correctly records the discussion, is as follows: the decision to explore legal action against the EFF that was taken at our last Council meeting in November 2018 was taken forward by ManCom. The case is now proceeding in the Equality Court and a judge has been allocated. So she says ManCom has the authority, but she says in any event, and this is at paragraph 37, the decision by ManCom to, after exploring legal avenues, to institute this complaint served again before the decision, before Council, Council accepted it and, for all intents and purposes, if it wasn't already authorized, ratified it. She also says, my lady, which is important at paragraph 38, that Mancom has been authorizing litigation in the name of Sanef for more than 20 years, the 20 years of its existence. In terms of clause 7.16, Mancom is required to report on the activities and financial and other affairs of the forum, which is Sanef, at the annual general meeting. In my 4 years as a member and office bearer of Sanef, I have attended to all its annual general meetings. Sanef has litigated extensively during this time. The authority of Mancom to institute litigation has never been queried, either at the AGM or otherwise. So, my lady, our submission is that Sanef was properly authorized by Mancom. Mancom is the body that is required to deal with the day-to-day administration and the implementation of policy of Sanef. If there's any defect in Mancom's authority, which is over the years, members of Sanef have been quite content with Mancom to take these decisions, but if there is any defect, it was certainly ratified by Council on the 9th of February. So our submission is that the challenge to Sanef's authority is simply not correct. Sanef is properly before your ladyship. The Mancom has authorized the board and the council. The council is fully aware of it, and they have ratified it. There's nothing more to be said in that regard.
So for it to be ratified, it means the clause does not enumerate the management committee a power to institute, defend such legal proceedings. Is that your submission, Advocate Vega?
If there is a defect, our submission is that there's no defect in Mancom's authority to institute proceedings. If there is a defect, then the council has ratified the decision of Mancom.
Okay.
So what happened was, council said to Mancom, go and explore legal proceedings. Mancom explored and took a decision to institute. The matter then was reported back to council. After the institution, council noted that the matter was now proceeding in the Equality Court and a judge had been allocated. Our submission is that is a ratification of a decision that was taken. If ratification is required.
Thank you.
Lady, I should also just point out that each of the individual complainants in their affidavits, I'll just refer to Ms. Munsen's affidavit. They all say in their affidavits, and for example, page 72, paragraph 3, that they've read the founding affidavit of Mahlatse on behalf of the first complainant. I align myself with the contents of the complaint, and I support the relief sought. I confirm that the contents of the founding affidavit are true and correct insofar as they relate to me. So there are three things there that each of the individual complainants says. The first is that, well, they align themselves with the contents of the complaint. The second, that they support the relief sought. The third, that insofar as the founding affidavit refers to them, it is correct. So what they're saying in the first point, by aligning themselves with the contents of the complaint, is that everything that is said there as a complaint, they take on board as being their complaint as well. There is one complaint before this court, and it is put forward by all 6 complainants jointly.
But if you look at the supporting affidavit by Mr. Basson, and
Yeah.
I'll just refer to it at page 169, it also authorizes Matlasi to sign Form 2 in terms of the Section 20 of the Equality Act on her behalf, which is not the case in respect of the second respondent.
Yes. Yes, my submission would be that is superfluous. Because he says in paragraph 1, he says, I am the fourth complainant in this matter. He says in paragraph 3, I align myself with the contents of the complaint and I support the relief sought. And I suppose what he's saying in 4 is that he's authorizing Ms. Matlasi to sign the Form 2.
And that authorization is only in respect of Mr. Basson, Mr. Dupree, and Mr. Bateman.
Yes.
So I was wondering, are they members of the Sanef, or is it superfluous like you're saying?
It is superfluous. I know that Mr. Basson, I think, is the treasurer of Sanef.
Oh.
Because what they all also do say, my lady, is that right at the end of each of the affidavits, they say, I ask this court to grant the relief set out in the form to which this affidavit is annexed. So they're all attaching their complaints to that form, which is signed by Ms. Matlasi. My lady, I come to the issue of the jurisdiction of the Equality Court. A lot of what we say in our heads of argument here is really trite. I point out that Section 16(1) of the Constitution includes specifically freedom of the press and other media. Section 9 is the section that guarantees the right to equality. We know that the Equality Act was promulgated in order to give effect to Section 9. Section 10 of the Equality Act deals with hate speech. And it says that no person may publish, propagate, advocate, or communicate words based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention to A, be hurtful, B, be harmful, or to incite harm. And then we've added the words and or to promote or propagate hatred. So what we are saying by that and or is that if you look at Section 10 of the Equality Act, 10(1)A, B, and C, our submission is that it's A or B or C, yes, or it could be A, B, and C.
Yes.
In other words, you can have one or more of those satisfied, and that will be sufficient for the purposes of Section 10. I don't believe that that's controversial. Our submission is that the respondents have indeed published, propagated, advocated, and communicated words that could reasonably be construed to demonstrate a clear intention to be hurtful or harmful to, or to incite harm or promote hatred at each of the individual complainants and journalists generally. Now, my lady, as I said, all of this is contained in the chronology, but what we've done in our heads of argument is we've isolated some examples for your ladyship of the kinds of speech to which objection has been taken, either by the first complainant, Sanef, or by one of the individual complainants. And the references for each of these will be to one or other of the complainants. The first is from Ms. Munsami's affidavit, and it relates to a statement made by Mr. Malema on the 5th of July 2018. And your ladyship will see that this was about 5 months, or four months before the speech that was made at the Zondo Commission. And Mr. Malema said this. He said, journalists, once they take sides, are politicians. They must be treated as politicians. The same way we treat Malusi Gigaba, the same way we treat Mbalula, the same way we treat Zizi Kodwa, is the same way we will treat journalists who descend into the arena. And he continued, Ranjeni, meaning Ms. Munsami, is a politician. All EFF people must know that in dealing with Ranjeni, you are dealing with a politician. She is a politician that has proposed to other politicians, Pravin Gordhan must be made president. Only a politician can make that suggestion, and she will be treated as such. She is a politician. Milady, I pause there because from what I could, well, certainly from the answering affidavit of the respondents, and from what I could gather from our learned friends' heads of argument, this is indeed the position that is taken by the respondents. That is that journalists who write in a particular way will not be treated as journalists. They will be treated as politicians. And that particular way that they write is when they write critically about the EFF, then we will treat them as politicians. On the 20th of November, this comes from the affidavit of Ms. Matha. This is outside the Zondo Commission. He said, let's attack fighters. Let's occupy every street, every house, every space in society. Let us not leave the enemy to chance. Where we meet the enemy, we must crush the enemy. On Facebook, Twitter, social media, be there. Guard the revolution. When the enemy raises its ugly head, don't hit the head, cut the head. No time to entertain enemies of revolution. We must protect the revolution at all costs. Milady, later on in our heads of argument, we deal with the interpretation of political speech, and we refer to a case that was in this court, in the Equality Court some time back, the matter of AfriForum versus Mr. Malema, where Judge Lamont spoke about how to interpret speech made at a political rally or political event. Our submission is that in accordance with what this court has already said, these words must be given their ordinary meaning. Mr. Malema contends that when he says let's attack, he doesn't mean let's physically attack. And the respondents, when Mr. Malema says let's occupy every street, every house, every space in society, they say he doesn't literally mean every space in society, because if you read further, he just means Facebook, Twitter, and social media. But that, we submit, is not what he says. And that, we submit, is not what is understood by the ordinary person listening to such a speech. He says, every street has a meaning. It means every street, every house, every space in society. Wherever people are, wherever we are, we will not leave the enemy to chance. And then he says, when the enemy raises its ugly head, don't hit the head, cut the head. The respondents say that's not a call to violence, that's not inciting violence. But that's exactly what it is. It's a call to violence.
But the statement you referred to earlier on of the 5th of July 2018, does it also amount to hate speech about politicians?
Well, we submit that it has within it, I'd have to argue a little bit more, and it's there for, it's there to show that things didn't start on the 20th of November. Things started before. 4 months before then, the respondents, and Mr. Malema in particular, were already saying, we've got to treat these journalists differently. These are not your regular journalists. They must be treated as politicians. And we submit, he doesn't say it, and I'm not, but it's implicit in there, that they must be treated roughly.
Are you referring to it, Mr. Beggar, as background towards the speech at the Zondo Commission?
Yes.
Okay.
Yes. But it's not a calm message about how to treat journalists. This is upping the ante. This is saying journalists who behave in a particular way, journalists who report in a particular way, will be treated differently, in a harsher way, than other journalists. At the same speech, this is on the 20th of November, I'm now at 18.3. And after saying, cut the head, crush the enemy wherever you find them, Mr. Malema says this. He says, Peter Bruce, Max Duprier, who is one of the complainants, there is Ferial Hafaji, there is Ranjani Munsami, also a complainant. There's another one from Cape Town called Palesa Morudu. There's another called, this one that was the CEO of the Gender Commission, Nomboniso Gasa, and the husband, and that Pierre de Force. That's the Ramaphosa Defense Force. You must write them down. Everywhere you see their names, attend to them decisively. You must attend to them decisively. We submit that too is a call to violence. Attend to these journalists, these particular journalists, write down their names, attend to them decisively. Now, Mr. Malema and the EFF say that we're ignoring what he said later in his speech. We're not ignoring it. In fact, it's referred to in the founding affidavit of Ms. Matlasi at page 16, paragraph 18, where Ms. Matlasi says, having incited the first respondents, members and supporters to violent action against journalists in particular, the second respondent then sought to wash his hands of the consequences of his hate speech by making the following statements. And this is the passage that is relied upon. These people I'm mentioning by name. You must engage with them from a civilized point of view. You must never be violent with them. Violence is for the empty heads. In the EFF, we thrive through superior logic. Some of them are women. You must be extremely gentle with them. And don't use their gender status to attack them. Engage with them from an intellectual point of view. Display discipline and intellectual superiority when engaging with them. He also said, immediately after that, he said, and don't kill them. So, at one part of his speech, he says, deal decisively with the enemy. crush the enemy, cut off the head of the enemy. And then later on in his speech he says, don't be violent, don't kill them. And the respondents say, well, then that's not a call to violence. Our submission is, you can't make speeches like that. You can't say in one part of the speech, cut off the head of the enemy, and another part of the speech, don't kill them. And the reason you can't say that is because, first of all, you're sending a mixed message. At best for you, you're sending a mixed message. But at worst for you, people can hear selectively. But then it gets worse, Malema, because what the EFF then does after the speech is the EFF then posts certain parts of the speech on Twitter at different times. So in 18.4, at 4:24 that afternoon, the EFF tweets, hashtag Pravin must fall, Malema, : let us attack fighters. Where we meet the enemy, we must crush the enemy. When the enemy raises its ugly head, don't hit the head, cut the head. Exactly that part of the speech that is a call to violence. Followed on by another tweet some 15 minutes later. Hashtag Pravin must fall, Malema, Peter Bruce, Max Duprier, and Jenny Munsami, Ferial Hafaji, Valesa Moruru, Nomboniso Gasa, and her husband, Pierre de Force. That is the Ramaphosa Defense Force. And then 4 minutes later, Malema, everywhere you see their names, you must attend to them decisively. They are no different to Bell Pottinger, who was hired as a machine for the Guptas and Jacob Zuma. There is another tweet which is contained in Ms. Matlasi's affidavit, but not in our heads of argument, which came after, and I'll just refer your ladyship to it. It's at page 32, MM 2.4, which was sent 5 minutes after the third tweet that I just read out. Malema, these people I am mentioning by name, you must engage with them, you must engage with in a civilized manner and not violent. Violence is for those who are empty in the head. The EFF thrives on superior logic. So some people will read all 4 tweets, and some people will read only 1 tweet, or more than 1 tweet. And again, the difficulty, the problem with this kind of speech is that at times, in the speech and in tweets, there is a call to violence against certain named journalists in particular, and journalists in general, journalists who are part of this Ramaphosa Defense Force, or journalists who are writing negatively about the EFF. Journalists whose opinion clashes with the clashes with what the EFF considers to be appropriate speech by journalists. Later on that day, also the 20th of November, Ms. Ferial Hafaji tweeted, the references are to be found in Ms. Matlasi's affidavit. Ms. Hafaji tweets the following. She says, Malema says this in a speech, and then EFF media turns it into a tweet, which goes viral. We get attacked by EFF trolling army. It happens every day. Once marked like this, it's open season by the digital army. At Ranjeni M, that's Ms. Munsami, is threatened and attacked every day. This must end. And Mr. Malema responds to that tweet in a tweet of his own, and he says, it won't end. You are Ramaphosa Defense Force. just start acting professional, it will end automatically. So what Mr. Malema is saying is, if you write what we like, we will stop this agitation towards you. If you don't write, if you continue to write what you write, which is what we don't like, we will continue to call you out in the manner that we have already done. And my lady, that appears to be the attitude that is adopted by the respondents in this court. And that is that these journalists are, because of what they have written, they have identified themselves as fair game for this abuse. That is the position, and if I've characterized the EFF wrongly, my learned friend will correct me, but my understanding is that is the position that the respondents have adopted in this court. These journalists are acting like politicians, and we will continue to behave in the manner that we have behaved towards them. And what's also revealing from Mr. Malema's tweet, it won't end, is that Ms. Hafaji says, we get attacked by the EFF trolling army. It happens every day. Malema says this in a speech. The speech goes viral. We get attacked by the EFF trolling army. It won't end. And yet, the respondents in their papers say you can't blame us for the actions of our supporters. You can't hold Mr. Malema and the EFF liable for tweets that come from people who say that they're supporters of the EFF. For all we know, they may not be supporters of the EFF. They may be fake accounts, say the respondents. But Mr. Malema knows that when he says something, or when he tweets something, or when the EFF tweets something and it goes viral, there's going to be this abuse, this online abuse that comes from this, what Ms. Hafaji calls trolling army. And he says that will continue until you journalists start acting differently. The next one is 18.8, and that comes from Ms. Van Wyk's affidavit. This was on the 24th of November, 4 days after the speech. Ms. Van Wyk, who is one of the complainants, takes a similar line to Ms. Hafaji. And she tweets, Julius Malema has to take responsibility for violence meted out to journalists. He is stoking the flames of a campaign against journalists whose work he disputes, and ultimately endanger the lives of journalists. And Mr. Malema tweets in response to Ms. Van Wyk, he says, you are sick. Go to hell, Satan. Now, your ladyship will see, when your ladyship goes through the chronology and looks at the tweets that followed this, your ladyship will see many of the EFF supporters in their tweets using the same language about Satan in relation to Ms. Van Wyk, and going even further and using some of the most abusive language towards Ms. Van Wyk, including misogynistic language. It is quite appalling. I'm not going to read those tweets out in court. They're on the papers. They are quoted directly and accurately in the chronology for your ladyship to read. But what this shows in our submission is that, once again, Mr. Malema and the EFF are aware that what they say has consequences. And if they're not aware, then they certainly would be made aware by tweets such as this one or Ms. Hafaji's tweet, that what you say has real world consequences, where where your supporters, or people who say they are your supporters, take your lead and start to abuse the very journalists that you are attacking for the way in which they have written about you. And when it comes to Ms. van Wyk, your ladyship will know that Ms. van Wyk wrote a lot of articles, several articles, about the VBS Bank. And she got attacked, and she describes this in her affidavit. She got attacked on Twitter by Mr. Malema and the EFF for the things she wrote about them in those articles. Now, we're not in this application seeking to prove the truth of anything that Ms. van Wyk wrote. What we are saying is that she wrote certain articles that were critical of the EFF. As a result of that, she was subjected to this abuse and harassment by Mr. Malema, other leaders of the EFF, and that then translated into the kind of abuse that I described earlier against Ms. van Wyk from numerous supporters, or people who say they are supporters of the EFF online. So there is this link. And for the respondents to deny that there is such a link is simply to deny what everyone knows. And that's in fact proved by other tweets that I'm about to refer your ladyship. On the 30th of November, there were tweets that were posted by Dr. Ndlozi, who is a spokesperson of the EFF, and Ms. Nkalipi, who is the EFF Deputy Secretary General, I believe. And this related, and your ladyship will see it in the papers and in the annexes, it related to an award ceremony which Vodacom hosted for journalists. And there was a picture of the award ceremony, and there was a photograph of a scene at that ceremony. And Dr. Ndlozi tweeted the following. He said, "Fighters, don't be surprised when Vodacom gathers journalists to strategize on how to deal with EFF. It just means our fight is right where it belongs, in the belly of the beast. Hashtag white monopoly capitalism. We would not be doing well if they were not all uniting against us. ICG." And then Ms. Nkalipi tweets, "Vodacom have declared war against EFF. Let's go. Let's see who will win this war. Fighters, let's go." And as Mr. Bateman tells your ladyship in his tweets, that these two tweets of Dr. Ndlozi and Ms. Nkalipi were published within minutes of one another, and that shortly thereafter there was the trashing of certain Vodacom premises by people claiming to be supporters of the EFF. To suggest that tweets don't have real-world consequences is simply to ignore evidence such as this. And it's this kind of evidence that the respondents would like your ladyship to have struck out. And then on the 3rd of December, there was a retweet posted by Mr. Malema. I need to just give this some context, my lady. It also comes from the affidavit of Mr. Bateman. The references are there. What happened was Mr. Bateman wrote a story about Mr. Malema and his family living in a particular house that belonged to a certain person. And the suggestion was that Mr. Malema was receiving benefits from that person.
what then happened was that another journalist, Charles Poe, tweeted a picture, I think a Google Earth picture, of a house with an arrow pointing to it to say that was the house where Mr. Malema and his family were living. And that rightly caused an outcry, because it meant that it could endanger the lives of Mr. Malema and his family. Your Ladyship will know from the papers that Sanef, very soon after that, issued a very strongly worded repudiation of Mr. Poe's conduct. And Mr. Poe subsequently took down his Twitter post. It was assumed that Mr. Bateman was responsible for identifying the house in which Mr. Malema was living and giving the details of where his family was living to the world. But it wasn't Mr. Bateman, and that much is clear from Mr. Bateman's affidavit. But then a supporter of the EFF tweets, in response to all of that, that a list of Stratcom journalists' home addresses would be a good Christmas present. The implication of that, my lady, is also clear, and that is that let's get the home addresses of these journalists so that we can pay them a visit. And it's not a visit to go and have Christmas cake with those journalists. It's certainly a threat to find where those journalists are living and to go and meet them with violence. Mr. Malema sees that tweet and retweets it. Mr. Malema and the EFF say they're not saying that it's a good thing. They're not endorsing this tweet. But, my lady, with respect, that's exactly what they are doing. In this environment, where you have targeted journalists, where you have called them the enemy, where you have said, let's crush them, let's cut their heads off, in that environment, to retweet a tweet that in itself insinuates violence can only mean endorsement. If Mr. Malema was seeking to highlight this tweet for any other purpose, he would have said, this is what people are saying, don't do it, violence is not good, don't threaten these journalists with violence. As Mr. Bateman says, and as we submit, my lady, the retweeting of this particular tweet is an endorsement by Mr. Malema. Yes, let's get the addresses of these journalists so that we can go and pay them a visit. There's no other explanation put forward for why this tweet was retweeted. And then, finally, there's a tweet that appears in Mr. Basson's affidavit. This was in December of 2018. There's an EFF supporter whose Twitter handle is Tseko TSK. And as Mr. Bateman says, it's Mr. Basson, I beg your pardon, says on Twitter, this supporter is seen with his arms around a prominent leader of the EFF. He tweets, but for the first time I agree with him. We must slaughter these white animals if they kill black Africans. Actually, we must come up with action to kill white people like you, Adrian Basson. Mr. Basson tweets, he says, just opened a criminal case of intimidation against EFF supporter Tseko for threatening to kill me. SA Police Service, very professional, and I will assist them in tracking down suspect. No condemnation yet from EFF. Mr. Malema sees that tweet, my lady, and he tweets, we won't do it.
The EFF will not condemn one of their supporters threatening to kill a journalist. Milady, that is endorsement of violence. And that is why we submit that each of the statements that we've referred to could reasonably be construed, and we're using the words of the test, to demonstrate a clear intention to be hurtful or harmful to, or to incite harm or promote hatred at the individual complainants and journalists generally. Milady, I see it's 11:15.
Yeah.
Would it be appropriate to take
Yes,
an adjournment?
I think let's adjourn
Thank
for
you.
tea until 11:30.
All right.